Hello, my name is Mike Downey. I'm Director of Lifetime Planning at JCP Solicitors, East Wales, and I'm delighted to have been asked to talk to you today about lasting powers of attorney and dementia by Kim Ann Williamson, MBE, Civil Service Local Coordinator, Cymru Wales Cabinet Office. Today is Wednesday, 22nd April, and the time is 10:45. You may see that I'm talking to you from my dining room as I'm working from home in these unusual times. Thank you to Kim's colleagues in the Civil Service Wales who have submitted questions about lasting powers of attorney, which I hope to address. I am an Alzheimer's Society appointed dementia champion, so I deliver Dementia Friends information sessions. Now, one thing which everyone can do by way of forward planning is to put in place lasting powers of attorney. And the first question from Kim's colleagues is, well, what is a lasting power of attorney? A lasting power of attorney is a legal document which allows the donor, that is the person giving the power, to appoint one or more persons, known as attorneys, to make decisions on their behalf. Now, the donor must be over the age of 18, must live in the UK or be a British citizen, and most significantly of all, must have the mental capacity to make the lasting power of attorney in the first place. So, lasting powers of attorney come in two parts. The first part is health and welfare lasting power of attorney. Now, this document is given by the donor and enables the attorneys to make decisions only if the donor no longer has the mental capacity to make those decisions themselves. And the types of decisions which can be made under a health and welfare lasting power of attorney include such things as where should the donor live, whether the donor takes medication, what clothes they wear, whether they visit the doctor, all types of things like that. And in the lasting power of attorney for health and welfare, the donor can give an advance directive about life-sustaining treatment. So, in other words, if something terrible happened to the donor, then the attorneys know in advance that the donor doesn't want any life-sustaining treatment and is able to discuss that sort of information with the treating doctors. The second type of lasting power of attorney is the property and finance power of attorney. Now, this can be used as soon as it's been registered with an organisation called the Office of the Public Guardian, and it enables the attorneys to have control over the donor's finances. That's not to say that the donor absolves him or herself of all responsibility unless they want to do so. It's like a safety net. In the event that somebody needs to use the power of attorney, for example, to go to a bank or speak to somebody like British Gas on the telephone, then they can do so, and it's as if the person they're dealing with was dealing with the donor themselves. Another question which has been raised is, can you have more than one attorney? And the answer to that is yes, you can have as many attorneys as you like. And the attorneys can either act together or they can act together and or separately. I always recommend that attorneys act on what's called a joint and several basis, because if you make the condition that all the attorneys have to act together, then this can be impractical at times. For example, if one attorney is on holidays, or if something should happen to the attorney and perhaps they no longer have the mental capacity, or if they were to die before the donor, then this unfortunately would invalidate the whole document unless the power is on a joint and several basis. That's not to say that the donor can't stipulate that some decisions have to be made by all the attorneys and others can be made by one attorney alone. So, for example, if you were making a decision about life-sustaining treatment, the donor could specify that all the attorneys have to act in agreement. Another question which has been raised is, can attorneys be changed? The answer to that is no. Once the document has been registered with the Office of the Public Guardian, then that is it. You can have replacement attorneys who can step in the event that something happens to one of your nominated first-line attorneys, but only in those circumstances would that happen. If you wanted to change attorneys for any reason, then I'm afraid you would have to make a completely new document. Somebody's asked what's the timescale for making a lasting power of attorney. Well, from the time that the document is completed, and this can take a few weeks because the attorneys have to sign, the donor has to sign, somebody who is called a certificate provider, which is either somebody who's known the donor for a long time or is somebody like a solicitor or doctor, to say that they understand what they're doing and that they're happy to proceed. Once all that has been done and the document has been submitted for registration, then the Office of the Public Guardian, which oversees lasting powers of attorney, takes between 8 and 10 weeks to register the document. And when it comes back, there's a perforated stamp which says validated throughout the document. And once that is back, the document can then be recorded with places like banks, building societies, etc., and can be used on behalf of the donor. The final question which has been asked is the cost. Well, the cost of registration is £82 per part of lasting power of attorney. So if you register both lasting power of attorney for health and welfare and property and finance, then the registration fees amount to £164. There are, of course, other charges, which would be the cost of the preparation by the solicitors who undertake this for you. I hope that's given you a little insight into lasting powers of attorney. Thanks once again to Kim Ann Williamson for asking me to give this short talk. Thank you very much, everyone.